Good afternoon, everyone. Hello. There are still a couple of seats in front if you can't find ones in back. Also, we could maybe take down a chair or two if you need one. Thank you. And thank you to the team at BKC here. And thank you to our HLS lecturer, Alan Rell, for making the introduction today to introduce us to Julie, to invite her to speak with us. My name is Tara Kripowitz. I'm the managing director here at BKC, and I'm delighted to welcome and thank you for joining us at the sixth in a series of lunch events that we've had here at the center that are sponsored by the Orrick Fund for the Colloquium on Cybersecurity and Cyber Law. Please join me in warmly welcoming our guests today for this fireside chat. Julie Brill serves as Microsoft's Chief Privacy Officer and Corporate Vice President of Global Privacy, Safety, and Regulatory Affairs. She leads the company's effort in the tech policy, regulatory, and legal issues that underpin the world's digital transformation. Prior to her role with Microsoft, she served for 6 years as a commissioner of the U.S. Federal Trade Commission. As commissioner, she worked tirelessly on issues of critical importance to our consumers, including privacy, fair advertising practices, fighting financial fraud, and fair competition. Professor Aileen Nielsen is a visiting assistant professor here at Harvard Law School, where she teaches privacy law and torts. Her research focuses on the interplay of law and technology, drawing on empirical methods and private law topics. She has written 2 trade books on machine learning and has also worked in industry as a data scientist and is a faculty associate here at Berkman Klein Center. For our virtual attendees, thank you for joining us. Please note that this event is being recorded. However, audience members will not be shown. We strive to create inclusive and accessible events. For any questions, comments, concerns, or ideas for future programming, please contact us at events@cyber.harvard.edu. Your feedback is critical to our success. With that, I thank you again for joining us today, and I will hand over the mic to Julie and Aileen. Thank you.
Thank you. Julie, thank you so much for making the time to speak with us. Is my mic okay? It sounds a little funny up here, so I just want to, it's not okay.
It's a little soft.
It's a little.
Yeah. There you go.
How's that?
Do you want to use a handheld?
Is that better? Or shall we use the handheld mic?
That's getting better.
It's getting better?
Yeah.
Okay. So Julie, thank you so much for making the time to be with us today. For starters, just to kick off the conversation, keeping in mind that we have so many law students here who are interested in tech law, privacy, AI, it would be great to know how someone like you came to be in this space, sort of what led you here. I imagine it was a very different time when you kicked off your career, and yet you find yourself at the cutting edge. So how can they get to where you are?
Wow. Well, first of all, let me thank you and the Berkman Klein Center for inviting me here. It's really something I really enjoy doing, which is sort of touching the future. And you guys are the future. And I can tell you about my path towards that, or towards where I am today. But only you will be able to sort of pick up and thrive and help technology be trustworthy and also drive the kind of economic change and growth that we desperately need. So my background, it actually might be really helpful for some of you to know about it because there is a lot of political change going on, and I think you all might be thinking a little bit about where is the federal government going? What role might you have? And for some of you, it might be terrific. And for others of you, it might raise some questions. What I did right out of law school was I went to the States. So I did clerk for a federal judge in Vermont, had a lovely time there, and decided that it would be a really nice place to be. So that's one lesson. Like, be where you want to be, because you're going to be there for a while. You know, if you're here in Boston or here in Cambridge and you actually don't like cities, you don't have to be in a city. So I really enjoyed being in Vermont. My husband and I ended up living there for over 20 years and working there for 20 years. And I was in the Vermont Attorney General's office, which I absolutely loved. Now, at that time, there was no such thing in the United States as a privacy discipline. It was consumer protection. back then. And even in the consumer protection world, privacy was just beginning. So, I was very lucky in that I was doing consumer protection at the Vermont Attorney General's office. As you can imagine, the Vermont Attorney General's office is very, very small, which is actually a good thing. Lesson 2, you don't necessarily need to be in a huge place to have a really enriching career. The great thing about going to a place that's small is you have to be kind of a jack of all trades. You have to do a little bit of everything. And I really enjoyed that because I got to taste a lot of different flavors of what it meant to be a government official, what it meant to be an enforcer, someone who was trying to drive appropriate compliance, not only in Vermont, but really around the country. So I really enjoyed that. I gravitated towards privacy, in part a little bit serendipitously. This is sort of a third lesson, that serendipity is actually really important in one's path going forward. So there was a problem in Vermont where suddenly all citizens that owned a home were being, which is a lot of people, they're not necessarily big homes, but there are a lot of homeowners, were being tagged as tax deadbeats. And this was in sort of the late 1990s. They were being taxed as tax deadbeats because the credit reporting agencies were sending out vendors to look at records and they were misreading the records. And so everyone who was paying taxes were thought to not have paid their taxes. It was just a mistake, but it affected thousands and thousands of people in Vermont. So that was one of my first cases when I arrived at the AG's office. And they said, Julie, can you figure out what's going on here? And so there had been a lot of other states that were dealing with credit reporting issues at the same time. I tapped into those networks. I did a lot of work, and lo and behold, we discovered that there was this error. And it ended up with the three major credit companies at that time, major settlements with them on behalf of Vermont. It also brought me to Washington, D.C. to testify about the problems with the Credit Reporting Act. And as many of you may or may not know, or many of you may know, in about the late 1990s, the Credit Reporting Act was revised to address a lot of the problems that were existing for consumers. So it was a little bit of consumer protection, and it was also quite a bit about privacy. How are people using personal data? So it was a great start, and I just really enjoyed being in the AG's office. It brought me to a place where I was involved in many multi-state cases, suing the tobacco industry, suing Microsoft. It was sort of interesting to then wind up there, but in terms of antitrust. And I had a blast. I was able to do what I wanted to do. I was helping people and really involved in some cutting edge issues. And this was all at the state level. So after that turn of a couple of or several years, I got a call from the North Carolina AG's office. The attorneys general are a close-knit community. They worked a lot together. They know each other. And the North Carolina attorney general asked me to come to North Carolina to run his consumer protection and competition program. I went down there, loved it. This was, at the time, the attorney general was Roy Cooper. He is now the governor, soon to be leaving because he's term limited. But I worked there for a total of a year because shortly after I got there, I got a call from the White House asking me if I'd like to try to become a commissioner of the FTC. And I was like, what? Yeah, that sounds great. But it's a process. And I had to go through interviews, and there were a lot of people that were on tap for potentially getting the role. And I was lucky enough and privileged enough to get it. And being a commissioner at the FTC was really one of the highlights of my career. This was during the Obama administration. I was there for 6 years. It was just fabulous. I mean, I really felt like I was able to drive a number of key issues. My focus was on privacy. I did everything. All the commissioners do everything. We don't specialize in only doing competition or consumer protection or privacy. So, but I did focus on privacy. I also focused on data brokers, in particular, running some initiatives for the agency around data brokers. And it was just a tremendous opportunity. I learned a tremendous amount. Interestingly, though, when I went to Microsoft, in many ways, I feel like I had the opportunity to have even more impact than as a commissioner of the FTC, because Microsoft is global. It provides in many ways the infrastructure for governments, for other companies, really a lot of the digital infrastructure for the world. And I was asked to be the chief privacy officer and the head of what was then regulatory affairs. It's now safety and regulatory affairs. And I just find that what I get to do every single day is both incredibly important, challenging because it's complicated and because the world and the regulations are complicated, and also something where I feel like I'm impacting people's lives around the globe. And it's just an incredible privilege. So lesson 4, maybe last lesson, is you can start as a baby lawyer, right out of having a clerkship and going to an AG's office, doing what you love, being really impactful because you love it, and winding up where I wound up.
So I have a follow-up question.
Sure.
I'm often advising my students never to turn down any opportunity for greatness or extreme power, even when they maybe don't feel comfortable with it, and in particular because then they can give me some of that greatness and power. But that said, is there anything they could do to prepare if they want greatness and power in this particular domain? Or to frame it in a more mundane way, are there things that you sort of had to learn later that you would have liked to prepare sooner? Either technical skills, people skills, understandings about how the world works?
It's a great question. I'm going to answer it in 2 ways. I think the first thing that I learned is never turn down a conversation, because you never know where a conversation will go. The way I eventually got onto the radar screen of the White House was through a conversation with someone who had just been named the chair of the FTC, and there were a couple of openings. I went down not to push myself as a potential commissioner. I had no idea there were openings, but really to talk to him. This is John Leibowitz, was the chair of a great chair of the FTC during that time. Really to talk to him about the ways in which the FTC in the States could work better, the ways in which the FTC could improve. It was very substantive. And from that conversation, came a fabulous opportunity for me. The same thing actually happened when I got my role at Microsoft. I had known Brad Smith, who is currently the president and vice chair of Microsoft. I'd known him for a long time. And we were both at an event, and we just had coffee and we're chatting about sort of the state of privacy. It was an event in Berlin. It was around data protection. And we were talking about privacy, and he looked at me and said, I really need to get you at Microsoft. So I deeply encourage you to reach out to people. The worst is they'll say, no, I'm sorry, I'm too busy. And you just have to get toughen your skin for that. But honestly, if I'm any example for you or any inspiration for you, really great opportunities come from conversations, and you never really know when that's going to happen. So that's the first thing I would say. In terms of what do I look for when I'm hiring people? Maybe that's another way to answer. What are the skills that you guys could be thinking about building right now for a longer term future? When I think where privacy is going right now and where digital safety is going, as well as responsible AI, which are all 3 incredibly important trust domains within any organization like Microsoft, and particularly at Microsoft. And this is also true for security as well. It's really around data governance. And so I think it's important not only to understand the rules the laws that relate to data governance, but also to understand technically what does happen with data when you're talking about AI applications, or you're talking about digital safety systems, or you're just talking about data governance for a company. So having that cross breeding or fertilization between regulation and law, as well as the technical side, I think I mean, you guys must already know this, that's why you're here, but I think that is really what is going to be the future for the practice of law. I don't think the practice of law will just be in books. I think the practice of law will be much more practical in the sense of helping companies, guiding them in terms of how they can get better at what they're doing with their data in my domain. But also in, like I'm saying, sort of security, responsible AI, all of that is really about data governance.
Okay, well, I'm glad you mentioned AI, because talk about something that I think no one would have predicted would roll out in the very way it has in the last few years and suddenly become so socially important. AI is certainly sort of one of the buzzwords of the last few years. So thinking also about the role of serendipity, right, and sort of the futility of prediction, I'm nevertheless interested in your thoughts on both the near future and the far future, right? So when we're thinking about the extent to which AI is an unusual or unique phenomenon, both for our society and for law to deal with, or not, because one can also be skeptical, I'd love to hear your perspective, especially given that your career has witnessed the creation of this industry that was sort of unthinkable.
Yeah, it's actually really interesting. I think right now what I've been thinking a lot about is the similarities between regulation of AI and the regulation of privacy. Because I think that there are a lot of interesting similarities if you go back in time, and particularly with respect to the relationship between the United States and Europe. So privacy in the United States, there was a time when the EU and the US were actually fairly close in terms of their approach, sort of the 80s and into the 90s. There was a lot of harmonization in terms of what was happening at the OECD, the kind of principles that were being developed. And the hope and belief was that both in Europe and in the United States, there would be comprehensive laws that would be enacted and adopted. And there would be sort of a harmonized approach around data. That did not happen. Of course, Europe moved forward with the GDPR, which is a very immersive and important law, not just for Europe, but actually globally. Many, many jurisdictions have adopted GDPR-like laws because GDPR was designed for that. Europe basically said, we're not going to let data flow anywhere unless we think that that jurisdiction is adequate or appropriate protections are established. It was a very, very smart move by the Europeans. They are very good legislators. They're very strategic, generally speaking. And that project was very successful. That is to populate the rest of the world, or most of the world, with GDPR-like laws. On the other hand, in the United States, we never really were able to adopt comprehensive legislation at the federal level. So back to what I talked about before, who stepped in? Nature abhors a vacuum, privacy abhors a vacuum, and the states stepped in. And the states started adopting laws, first in California, and first focused on data breach notification, which was really not about data breaches. It was really about, if you talk to Congresswoman Spire, who was the first one to adopt and push these laws, she said, look, this wasn't really about notification to individuals. It was about getting companies to get their houses in order, their data governance in order, so that they wouldn't experience breaches and they wouldn't then have to talk about it. And it was also very cleverly done in my view. That law gets populated. All the states eventually have a data breach notification law, nothing at the federal level. Then you get California and some other states also adopting privacy laws. Colorado, California, now I think we're up to about 21 states that have comprehensive privacy laws, and still no federal law. Switching to AI, what I'm seeing is, and particularly in light of some of the changes in the administration, we have an EU AI Act. It is a fascinating act. I'm sure many of you are studying it and know about it. It will kick in February in the EU with respect to certain types of high-risk AI, those that are kind of assessing people for jobs, creditworthiness, things like that. And some other things kick in February too. But it requires about 60 standards to be written before we will really know how to comply with many of the provisions. So the European Commission has a huge job on its hand to fill out what the EU AI Act will really mean, especially for not so much the AI providers, but those who are deploying AI. Very immersive law, though. I don't know whether it will be adopted in the same way GDPR was adopted, more or less globally. That's, I think, a little bit of wait and see. But where the analogy comes into privacy is, one of the things that President-elect Trump has said is, and his team has said, is they are going to repeal the Biden administration's executive order dealing with AI. So that has probably been the hardest regulation that we've had to date in the United States on AI. So likely that will go away. What is going to happen? California will probably step in. Now, there was a law that was adopted by the California legislature. Governor Newsom vetoed it because he said it went a bit too far. In all likelihood, there will be adjustments made. And given where Governor Newsom is right now in terms of wanting to move forward with a lot of the initiatives that the state wants to do, I predict that there will likely be a California AI, a horizontal law regulating AI coming from California. And then what will happen after that? It will be interesting to see if it follows the pattern of privacy. I personally think that it would be good to have a federal law so that we have a baseline of how to ensure that AI is safe, that it is responsible, that it is being deployed responsibly. I think that that's a good thing. I think that the United States could build on and learn from potentially mistakes that have been made in Europe and create an even better law. I just don't know. I'm seeing history starting to repeat itself at its very early stages right now.
I could not agree with you more that it seems very much like deja vu all over again.
Right. Right.
As I mentioned when we met earlier today, I am an empirical legal scholar, and I also integrate this into my teaching of my privacy law course here at Harvard Law. And one of the things I talk to about my students often is sort of what's on the books versus what's actually enforced. So I wonder if you have any thoughts vis-a-vis what constitutes a good law when we're thinking about what we're actually trying to accomplish and whether we think we can. And so what your thoughts are both on existing privacy laws and sort of what is the best case potential AI law we could even hope to have?
It's a great question. I already, alluded to some laws that I think appeared to be about one thing, but actually did something else that was really good. The data breach notification law first in California and then now 40, actually I think now it's all 50 states. What GDPR did that I think was really very clever, there were many things in GDPR that were very clever, but one of them was requiring data subject rights. So the ability to access, to delete, to correct one's own data. And the impact that provision in and of itself had on a company like Microsoft was enormous. It's really hard to fathom for many people the scale at which Microsoft operates. Just to give you a couple of examples, and then I'll get back to the DSR, the data subject rights issue. We analyze, these numbers they actually blow my mind because I've only been at Microsoft, about 8 years, but The security teams analyze 90 trillion signals a day to assess security issues and other issues that we need to make sure that our system remains safe. Again, it's a global system. It runs quite broadly. We experience attempts to infiltrate our systems about 600 million times a day. I mean, it's just sort of mind-boggling, right? And we're not the only ones. Amazon has recently said, yeah, they get about around 700 million attempts to enter in some fashion a day. But it's just to try to get a feel for scale. That's why I'm giving those numbers to you. So back to data subject rights, the company was figuring out, okay, we're going to lean into this law. We're going to demonstrate not only that we are complying, but that we can help all of our customers comply. Because again, one of the things about Microsoft, again, similar to Amazon with AWS, we do have consumer services, consumer-facing services like Bing and LinkedIn and GitHub and stuff like that. But we also have many, many customers that are businesses of their own that we are providing services to. In the GDPR context, we are processors in many, many circumstances, and our customers are the controllers. So GDPR, how do we do this? Data subject rights, because someone's going to come to us and say, I want to see my data. And they're not going to be okay if we just say, okay, well, here's your data from one of our subsidiaries, from Bing, let's say, or LinkedIn, and that's it. Because what they want is the data that Microsoft has about them. So what we did is we built a pretty sophisticated, a very sophisticated infrastructure for pulling data about individuals when they asked for it, so that we could delete it, they could see it, they could correct it, et cetera. So this is a long way of saying, like, so just that surface requirement that you're going to allow individuals to see their data, correct it, delete it. When you're talking about at a large tech company, or probably any tech company, what it requires then is creating infrastructure around how to do that. And then the other thing that it did, probably more importantly than just the infrastructure, it caused us to go through a process of determining what data do we really need about individuals? Do we have a lot of data that actually we don't need, they don't need, it's decades old? And so the amount of data governance and data hygiene that was created by this one requirement was, again, enormous. It ran throughout Microsoft and all of its subsidiaries. So that comes to mind to me because I was deeply involved in making that happen. But I don't know how intuitive that was, first of all, for even the European legislators, or how intuitive that would be for folks like you. But those kinds of requirements, if you're really going to get them right and repeatable and scalable, requires technical infrastructure, and it requires data governance. And I'll just say one other thing, because there's also, again, an analogy to AI here. One of the things that we tell our customers who want to start deploying AI, like Copilot or use Azure OpenAI, use any of the 1,000, almost 2,000 foundational models that we have on Azure OpenAI. One of the things that I tell customers, the first thing they need to do is data governance. If they're going to use AI, like in their own systems, they want to make sure that the access controls around data, especially personal sensitive data, is strong and is what they want. Because the AI system will pull information if they're asked to. So an example, you're at a company, you are new, brand new, and you want to find out what everybody earns. And you go to an AI system, you say, what is the CEO earning? Or what are the board of directors getting? If you don't have appropriate access controls around that, the AI might pull it because it's just following the instructions. So data governance is a really important first step for everybody to put appropriate access controls on, for instance, HR data, employment data, or other data that you want to make sure it does get seen, it does get used, but only by the right people. That's what access control and data governance is about. So It's again another real interesting analogy between privacy and AI.
So I'm mindful that we are progressing through our time. I'm going to take the privilege of asking one more question before we open it up, but I'm sure there's a lot of interesting questions in the audience, so please have those ready. I loved how you talked about sort of the historical and legal contingencies that go into shaping a technical system, right? Either sort of its initial shape, as it may be with AI, given that it's sort of coming into the world where there is some robust, mature data governance framework out there that should necessarily be implicated, but also sort of the opposite situation that you also faced, where sort of you had that imposed on an existing technical system and then would have had to sort of build out capacity. This also reminds me of the perennial American argument that it's so great that we don't have federal data privacy legislation, because that's why we have our awesome innovation in the United States versus those anti-innovation Europeans. And of course, I'm sort of caricaturing the arguments here, but just to sort of take them at their most extreme. I'm not going to ask you to sort of comment on that, but rather to segue into what does it look like to run privacy operations at a global company that is dealing with these jurisdictions that not only have very different legal regimes, but even different sort of legal philosophies, innovation philosophies. What does that look like?
Yeah, I think for a very large company, it's probably easier than it would be for, I would say, sort of a medium-sized company that it doesn't specialize in technology, but rather uses technology of others. That would be the first thing. The second thing I would say is that this is actually not a new phenomenon to tech or AI or privacy. You look at banks or transportation systems or telcos. They have very different rules in different jurisdictions. So if they do want to go global, like Deutsche Telekom, just as one example, they're going to have to deal with different types of regulations in the jurisdictions where they operate. Our perspective is that we are a U.S. company, but we operate globally, and in each jurisdiction in which we operate, we very, very much want to be a local entity. So complying with local rules is very important. The reason why I say it's sort of somewhat easier for very large firms is that we can adapt a little bit more easily, create sort of spin-offs within our system to deal with certain jurisdictions. I just think that's harder for companies that are a bit smaller. So, a lot of people have said that something like GDPR really favored large companies. I don't know that it favored large companies so much as the difference in the laws, because there are, even though GDPR was followed in many jurisdictions in order for them to gain adequacy, as I mentioned before, there are fine-tuning, little differences or medium-sized differences that you need to fine-tune your system for. So I think it's that has probably caused more difficulty for entities to scale globally. I think I don't think regulation is the problem within, that is the barrier for innovation. I do think that it's often a combination of issues where you might have a strict or difficult to implement regulation, one that requires technical infrastructure. Also, though, there's a lot of other issues that go on around the globe. What is the price of energy? When you think, for instance, about the tech stack that is AI, I mean, AI is not one thing. AI is a lot of things, and there's a stack that AI is built on. It begins with land, it begins with connectivity, electricity, power, all of that. And there are large parts of the world that still don't have electricity. I mean, there's hundreds of millions of people that go to bed every night without having lights or any kind of electricity. So that is where kind of you begin with what can create problems for implementing some of this very important technology for economic growth. And then it's things like having a platform that you can leverage chips to make the foundations work, the foundational models work, and all the AI models work. But also, where do you draw those foundational models? That's often going to be at a platform, which is something that we provide and other companies provide. So we are providing the infrastructure for other companies to thrive in these areas. We're taking on those burdens of a lot of the regulatory requirements. So I'm sort of mentioning a couple of different things because I do think often this meme of regulation stands in the way of innovation is something that people talk about. And I do think sometimes it is true, but it often requires a much more nuanced approach and a nuanced and deeper view about what's really going on in a particular area before you can just sort of say, oh, we shouldn't have any regulation. Because at the end of the day, what regulation also provides is it allows people to trust a system. That's what standards do. I mean, standards, regulation, it's why, one of the examples that Brad Smith always uses is we go into a grocery store and we'll buy milk because we know that it's produced and it's according to standards. Otherwise, we might not buy it. We might say, oh, yeah, I don't know if this stuff is safe. So that's the kind of world that I think we're entering with AI. How do we know that it's safe? How do we know it's trustworthy? Part of that is going to be standards and regulation.
Thank you. I have many questions, but I know you do as well. So I guess we'll manage the mic.
Hi, thanks so much for all of your insights. I'm Priyanka Naniakara. I'm a postdoc in computer science. So I wanted to give you that context sort of for my question. I'm curious, when you think about the future of privacy, how you see the role of privacy enhancing technologies. So things like differential privacy, federated learning, secure multi-party computation, working in tandem with or the interplay between those and like policy, more in like a regulation sense of the term. And I think like part two of this question is, I'm curious what you think the computer scientist's role is sort of in the privacy space going forward.
Sure, those are great questions. Was everybody in the room at least able to hear the questions? Okay, great. I think pets are super important. Privacy enhancing technologies are super important. And I encourage you, if this is something you're interested in, to absolutely lean into it. And it's going to be even more important as we move forward with respect to AI. AI training, a foundational model training, requires a lot of data. We are spending a great deal of time explaining to regulators around the world that when data is used for training, that doesn't mean the data is going to pop up in a response to a prompt. It is a hard concept, and of course, then there's always going to be like errors until we get it perfect. But it's a hard concept generally, I think, for regulators to understand. Pets, privacy-enhancing technology, could be incredibly helpful as we move forward with still needing more data to ensure that our AIs are really keeping up with different languages, different ways in which people speak, really helping, from my perspective, the global South, which is very much going to need AI to help jumpstart some of those economies. In order to do that, you need data, and you need to understand the way people talk and what idioms are like and what they're thinking about in order to have an AI that's going to be helpful. And I think that's where something like whether it's differential privacy or whether it's some of the other pets that you mentioned, I think is going to be super important. So as important as it feels now, it's going to, I think, be even more important going forward with AI training models. I think policymakers, it's interesting. I spend a lot of time talking to regulators around the world, privacy regulators around the world. They all deeply support privacy-enhancing technologies, but I don't think, for instance, under GDPR, privacy-enhancing technologies currently are not able to kind of give companies a pass, not yet. I think the regulator, in the sense of well, you're using differential privacy, okay, we don't need to worry about the data that you're using. I think the regulators are still in the process of trying to learn whether or not individual personal data is truly protected with respect to these pets. They're interested though. They are interested. So I think there will be more acceptance of the use of pets as an appropriate response to completely anonymizing data. That's really what they're looking for. De-identified data, not good enough. They want completely anonymized in the context of GDPR in the EU. Oh, you got a mic? There you go.
Okay. Hi, can you hear me?
Yes.
So my name is Erica. I'm a tool here at HLS and used two interesting word choices that I was hoping you could clarify. I think they're kind of related. The first was when you're talking about access controls, about who are the right people to have this information. And so I'm curious what you mean by what is the right people? And then second, what you meant by delete data, because can data ever truly be deleted? And what makes Microsoft the right people to delete data? So what you meant by delete and what you meant by write.
Sure.
Thank you.
So access controls are something that's really important in the enterprise context. Sorry, I'm having a little bit trouble seeing you, but yeah. This is not a context of, sort of general consumer data that I'm talking about in terms of access control. What I'm talking about is the governance that any company, let's say Brill's bank, I have a big bank, you have to have controls over who can access different types of very sensitive data and who cannot. For instance, your security teams are going to have access to a great deal more data than, let's say, the tellers in the bank. I don't know, do they still have tellers? Let's just pretend they're still human tellers. Or even the ATMs. I mean, are not going to necessarily, should not have access to the same data that the security teams have access to. That's what access controls are. It talks about personas. It's around personas. What is your persona? What should that persona be able to do with data that is internal to the company? And what should it be able to access? It's a really important concept in the commercial and public sector space. It's not the same thing when you're talking about sort of consumer-oriented products, Facebook or whatever. I mean, Facebook will put access controls around the data. Who are the security teams? Who are the digital safety teams? Who are the privacy teams? What data can they look at? But it's not really a public-facing, outside of Meta where that takes place. I'm sorry, what was the second part? Oh, deleting data. GDPR says that individuals get to delete their data. So in that and actually most of the 20 states in the United States that have laws say that individuals get to delete their data. So in many instances, it is the law that gets to decide who deletes data or not. What I was referring to in terms of the data hygiene that came to Microsoft was just a lot of accounts had been deleted, didn't exist anymore. Microsoft, it's our 50th anniversary this year, so it's been around for a really long time and gone through many iterations in its existence. So we're really talking about, legacy information that nobody was using and actually should have been deleted in all likelihood, actually not in all likelihood, the vast bulk of it should have been deleted long ago. So it gave that opportunity to really go through and sort of say, okay, these accounts don't exist, these people don't exist, or this is non-personal data, in which case you don't even need to worry about that, but just sort of going through and cleaning that up. Is that helpful?
Yes,
we're gonna
that was very helpful.
Go
Thank
ahead.
you very much. I just wanted to say, so data, the deletion is permanent, or does it ever linger?
No, it's permanent.
We're going to take a question from the Sky Lounge.
Sure.
This is from Jacob. What AI tools do you incorporate into your work as a lawyer, and which applications of AI in the legal field do you find most exciting and disruptive?
It's a great question. I actually use Copilot a lot. So Copilot is one of the AI tools that features that are in Microsoft's productivity tools. But I don't think this is not a commercial. This is just what I use. I'll often use AI really just to answer kind of simple questions. Someone will, in a conversation, talk about Article 3, paragraph blah, blah, blah of the EU AI Act. And I'm not sort of ready to be in a position where I can say exactly what provision that is. So I'll just, put it into Copilot and it will pop up very, very quickly. So I find it really useful in a way for just what I'd call basic research. The other thing that Copilot and other AI features are very helpful for is kind of cleaning up writing that might not be as concise as it can be. So I will sometimes use AI for making my writing a little bit more elegant and concise. I also think this is not so much about AI, but one of the things that I find about people who are lawyers and are trying to communicate with executives, I kind of straddle both. I'm both a lawyer and I run a big organization and I receive a lot of information as an executive at Microsoft. I think much of the old school way of lawyers communicating to their clients is no longer particularly useful. I don't think in many circumstances what clients need are memos that outline an entire sort of opus of work or of a domain, but really just very specific answers to specific questions. And I think that AI will get lawyers to a better place of talking more succinctly and really getting to the issue that the client really needs to have answered. My team does still provide me with memos, and I'm working with them very hard on trying to understand what executive communications are like versus legal communications. They're very different. And so when you get out there in the world and you're communicating to executives, you might find some pushback on a lot of long memos over an issue where they really just needed like yes, no, or maybe, or like, what's the problem with this? Give me the 5 things I need to think about, that kind of thing. So it's a little bit of a different answer, or that's a different issue. But I do think AI will help hone in on what are the key issues that someone needs to know.
Hi, my name is Natasha. Thank you so much for a great talk. I have a specific question related to data privacy framework. What do you think about it? What do you think about the whole Schrems saga? Was it worth it? And do you think the data privacy framework will be upheld? Thank you.
It's another great question. So the data privacy framework I'm sure everybody here knows, but just in case, the data privacy framework was adopted a year or two ago as an adequacy mechanism for commercial data to be transferred from the EU to the United States. Again, as I said, there needs to be, the European Union requires that where data is flowing is an adequate jurisdiction that will protect the fundamental rights of European citizens. The data privacy framework came on the tails of 2 other attempts to get a system in place for that data transfer from Europe to the United States. The first one was Safe Harbor, and then the second one was Privacy Shield. When I was at the Commission, the FTC Safe Harbor went down, Privacy Shield was being created. I was very involved in the discussions and development of Privacy Shield. In terms of the new version, and both of those, were struck down, both Safe Harbor and Privacy Shield were struck down by the European Court of Justice pursuant to litigation that was brought by a gentleman whose name is Max Schrems. So their cases are known as Schrems 1 and Schrems 2. Max is a friend of mine, so the privacy world is actually a pretty small place. I think that the data privacy framework will survive a number of challenges that it is going to be facing. Number one, there will likely be a challenge to it that will go up to the European Court of Justice. Max has said that he's not planning to bring that case in his NGO. NYOB also has said it will not be moving forward with that. Of course, it's their choice one way or another, but someone will probably challenge the data privacy framework, and it will probably be come up in all the way up to the European Court of Justice. I do think that the holes that existed in the past have been plugged. I think it's a very strong system. It provides for all sorts of protections for Europeans, including basically an advocate that would go to the various courts that have been created within the Department of Justice to determine whether Europeans' data was accessed appropriately or not by the intelligence communities. I do think that one question that we're going to start to get, that is Microsoft will get and others who travel to Europe will get, is, well, will the administration in the United States continue to uphold the data privacy framework, or will it try to ratchet it down? My expectation is that the data privacy framework will be not touched by the new administration. I think we saw that in past changes of administration between the Obama administration and then the first Trump administration and then the Biden, and now I think with respect to the upcoming second Trump administration, a lot of the infrastructure that supports the data privacy framework, some of them are executive orders, some of them are rules that have been created by the Department of Justice. Those haven't changed over time, especially the executive orders. The rules are new. I just don't expect it to change. I think the business community is deeply supportive of it. I think many NGOs and much of civil society is supportive of it. Some not, but I think overall there's kind of a consensus that the data privacy framework does a good job. But ultimately, it may be decided by a court in Europe, by the highest court in Europe.
Hi, thanks so much for being here. My name's Michael, and my question's about the relationship or the role of that Microsoft plays with regard to different sovereigns around the world, and specifically thinking back to the 2015 San Bernardino shooting. To what extent do you think companies like Microsoft have a role to play in acquiescing with the state versus protecting consumer privacy?
Another really good question. So I have reporting up to me, not just the privacy teams and not just the digital safety teams, but also the teams that take in all of the requests that we get from law enforcement and from national security entities around the world. It's called my LENS team, Law Enforcement and National Security. And the reason why it's so impactful to have that team part of the same organization where the privacy teams sit and the digital safety teams sit, as well as telecom. There's a bunch of teams that roll up to me, including a new team that we call regulatory governance. Lawful access is very important. And at the same time, it needs to be done very carefully by an entity like Microsoft, and the other very large tech companies also get a lot of requests for data. We need to ensure that when we are giving data in a particular jurisdiction, that law is being followed, as well as the law of where the citizen is located, whose data is being accessed, if we know, who the citizen is. Sometimes we don't. So I think that it really is an area where you need to be smart, you need to be careful, and you need to always have in mind the fundamental rights of the data subject, which we do. And at the same time, when you think about it, the absence of providing data that will save children's lives because they've been kidnapped, will stop a massive cyber attack that is shutting down rural hospitals. All these are real examples. That will shut down a child pornography international group that is operating, let's just say, in a place like the Philippines, but affecting children in Europe or the United States. I mean, these are real examples of what my team deals with. And ensuring that you get data to law enforcement in an appropriate way and in a timely way is one of the most important things that we do to protect the world. And we get letters and commendations for the team, which is always acting as quickly as it can, sometimes within hours, to save lives. It's one of the most satisfying things that my team can do. So I don't know if I'm really answering your question. I think what I'm trying to do is explain to you that there's a lot of thought behind these systems and behind each one of these decisions. And they're sometimes very hard decisions to make, but they have to be made. And I feel really, really good about the team that we have. It's run by people from all sides of law enforcement to former privacy regulators, and it's hard. It's really hard.
I'm afraid we are coming to the end of our time. I sincerely wish I could take your privacy law course when you teach a privacy law course.
I'm looking forward to it. Yeah.
When are you coming to HLS to teach a privacy law course?
I would love to.
But secondly, since we have basically 2 minutes remaining,
Sure.
What are the parting words of wisdom you can leave us with, or what should we have asked you and not asked you?
I think, okay, so for those of you who are in law school as opposed to our postdocs, don't worry so much about your first job. Your first job is testing stuff out. It'll be okay. Don't worry that much about that. That's something that I wish I could have told my younger self now, because when I see my path, it sort of all pieces together in a puzzle, but you'll have so many opportunities. So don't worry so much about that. And I guess I would really emphasize, reach out to people, set up conversations. When I said don't turn down a conversation, I was also not focusing on be proactive about creating opportunities for yourself just to talk to people, because you will never know what you will learn. I told you about 2 of those conversations that really changed the trajectory of my career. Both of those I initiated. So, be proactive. You're your best advocate. There's no one that is better than yourself to be an advocate for yourself.
Well, Julia, thank you so much for
Sure.
taking the time to be with us.
Absolutely.
Please join me in thanking Julia.
It was fun. Thank you.
And thank you from the Burke and Klein Center to Julie and to Aileen. And thank you all for coming. Thank you in the lounge. As Bay mentioned at the beginning, we have a pretty quick turnover in this room, so please take your time in the lounge outside. There's probably more food out there. And thanks again for coming.